Real people, real cases. This is Verdict Watch.
Michigan versus Emily Boyd, file 25-43659-SM. I do see Ms. Boyd is with us. I believe today is set for jury status conference. Do we have a resolution of this matter?
We do, Your Honor. And a plea offer was extended by Ms. Brucker, where Ms. Boyd would be pleading guilty to a drunken disorderly in exchange for dismissal of the original charge. And we would ask if the court would be so willing to impose immediate sentencing.
All right. Ms. Brucker, is that an accurate statement of the agreement?
That's correct.
All right, so Ms. Boyd, the offer to you is to plead to a less serious charge of drunken disorderly in exchange for which count 1 domestic violence second offense notice would be dismissed. Is that your understanding as well?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
All right, in order to do that, you'd have to give up your trial rights. That is, you would not have a trial. Do you understand that?
Yes, please.
At a trial, you'd have the right to continue to be represented by your attorney, Mr. Dick. You'd have the right to have a trial by a judge or by a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present witnesses for your defense and get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof be on the prosecutor at all times. Finally, at a trial, you'd have the automatic right to appeal any error. However, if you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of those rights?
Your Honor.
Do you have any questions about any of those rights?
No, sir.
And then other than the right to an attorney, do you understand that you'd be giving up all of those trial rights if you enter a plea today?
Yes, Your Honor.
Knowing all of that, do you still wish to enter your plea today?
I do.
All right. I'm going to take some testimony from you. Would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, you can put your hand down. Has anybody promised you anything other than this plea agreement today?
No, sir.
Has anybody threatened you in any way in order to get you to plead today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes.
All right. The amended charge, or the new charge of disorderly person, or disorderly drunk, would read as follows. It would say that on or about April the 24th of 2025, within the city of Gaylord and Otsego County, that you did in a public area were drunk and disorderly, and that you were making a public disturbance while intoxicated. Is that true?
It occurred at my home, but
All right.
yes, true.
What did you do that makes you believe that you were drunk and disorderly at your home?
I consumed alcohol, and my boyfriend and I got into a big fight, and it escalated. And I don't think that there was violence. It was more just a scuffle of getting belongings out the door and things of that nature.
I'm having just a little bit of trouble hearing you with the audio. Could you repeat what you just said a little bit more slowly?
Yes, I had consumed alcohol, and my fiance and I got into an argument. It got very heated, and I had asked him to get out because we lived together, and getting all of his belongings and things like that. I was disorderly in assisting him in getting his belongings out the door.
So part of this spilled out to the outside area of your residence.
Yes.
Can you tell me where it is that you live, and if there are other houses and other people in the area surrounding where you live?
I live in downtown Gaylord, so I have neighbors that weren't home, but I mean, you can see.
Okay, so where's the nearest house to you, to your house?
Across the street, and then across the parking lot.
All right. And so some of this disturbance occurred outside where the neighbors could see and hear?
Yes.
All right. You said that you were intoxicated. What did you have to drink prior to all of this happening?
Quite a bit. I had a lot of White Claws.
All right. And did some of this, what you called a disturbance outside, could you describe for me what it is that you did while you were outside, assisting him, as you put it, in removing his stuff?
Yelling, pushing things in his car, just kind of getting in his face. We were both screaming at each other. It was.
All right. And how long did that portion of the activities occur?
I have no idea, probably half an hour.
Okay, so it wasn't just a single yell at him and be done with it. It was an ongoing thing.
Yeah, it was a back and forth argument until
All
the
right.
police.
All right. Either counsel have any additional questions as to the factual basis?
No, Your Honor.
No, Your Honor. Thank you.
Any other promises, threats, or inducements that either counsel is aware of that were not placed on the record?
No, Your Honor.
No.
Do both of you believe I have complied with the court rule?
Yes, Your Honor.
Yes. Yes, Your Honor.
All right. Let me just catch up on my paperwork. All right. Ms. Brucker, is there any reason why we should not proceed directly to sentencing?
No, Judge. Victim did do a statement. I forwarded on to Mr. Horrigan and we're ready to proceed.
Oh, I do have that. I've also received a Catholic Human Services substance abuse assessment report. Is that from you, Mr. Dick?
Yes, Your Honor. I received that
Right.
this morning, and I copied the prosecution on it.
All right. Give me just a minute to read both of these documents. Ms. Boyd, what I'm going to do is I'm going to read these documents, and then I'm going to give both of the lawyers a chance to tell me what they want me to know about sentencing. And then I'm also going to give you an opportunity to tell me what you think I should know prior to sentencing as well. So that'll give you a chance to kind of collect your thoughts. All right, I have reviewed the Otsego County Prosecutor's Office Victim Impact Statement from Mr. McDonald. And then I've also reviewed the Catholic Human Services Substance Use Assessment Report involving Ms. Boyd, which was signed by Joseph Garrett. So, Ms. Brucker, your comments.
Part of the reason we came to this agreement is because of some of the things in her substance abuse assessment. It's apparent from her criminal record that she has a pretty serious alcohol problem, and it's pretty likely she wouldn't have all these issues with violating the law if it wasn't for the fact that she's drinking so much. So I'd ask the court to order that she follow the recommendations, and hopefully, let's put it this way, this will probably be the only time I give her some kind of break like this on a domestic violence charge. So hopefully she learns something from this and really takes to heart those allegations, because it seems like things are getting worse for her and not better. And that's all I have, Judge.
Thank you. Mr. Dick, allocution.
Yes, Your Honor. So, Ms. Boyd, she's a 38-year-old mother of two. The children currently reside with her father. She does recognize the fact that she has an alcohol abuse issue. And I want to address one thing in particular in the substance abuse assessment. It stated that she would not attend certain group sessions. And I think at that time she was still fighting herself whether or not she had a problem. Since this, she has come to the realization and succumbed to the fact that there's something going on here. She looked back at her past criminal history, which, like Ms. Brucker stated, she would probably not have if it were not for alcohol. The consumption of all substances is currently being monitored by Bear River. She is attending therapy there once a week. She's attending a medically assisted treatment program once a week, and she is meeting with a case manager from there once bi-weekly. The case manager, one moment. The case manager at Bear River is Heather Hreja or Hresa. And she did provide me with a letter this morning. I was expecting that earlier on, but I did just receive it to confirm she is in their treatment. Ms. Boyd, she is currently unemployed. The biggest reason being to a severe seizure disorder, which also prevents her from driving. Right now, she has no employment whatsoever. She was bartending prior to this incident, and she has since quit because she realizes that that type of environment is not sober friendly, and she's not going to be able to ensure that she remains sober if she continued to work there. So she is seeking to get back into her previous occupation of home healthcare aide. As far as anything else goes, Your Honor, like I mentioned, she was not working. Is not working. She has not been able to pay her bills. Her bills often were covered by her fiance, who was the victim in this matter. He did end up moving out and getting a second home so that he could help her abide by the terms of her bond. And that being said, she will need to move out. We are also asking that the no contact provision be discontinued at this time. And the specific allegation in this incident that arose to the level of the domestic violence charge was a kick in the butt as the victim in this matter was going out the door. So it's not a heinous assault or anything of that nature. So all that being said, we're just asking that the court would be extremely reasonable in assessing any period of probation that it finds necessary. If the court would be willing to assess fines and costs, that would be appreciated. However, she does have minimal resources at this time. And based on the minimal impact of the incident on the alleged victim, we would ask that the no contact provisions be removed and allow them to continue their life together and allow her fiance, Mr. McDonald, to support her. Recovery.
All right. Ms. Boyd, is there anything that you want to tell me prior to the imposition of sentence?
Yes. When I do drink, I am a terrible person. There's no doubt about it. And I'm very much aware of it. And I have been taking this extremely seriously. And I took it upon myself to not only seek therapy, intensive outpatient. I'm addressing my seizure disorder and medications. I know I should not have been drinking on those medications. It's a terrible idea. It's out of character for me. My fiance and I get along very well. We don't argue often. He's a safe environment. He doesn't drink or consume alcohol of any sort. And I'm hoping to I can get my fines and costs paid today. My family's willing to help me out. And I am going to continue my intensive outpatient treatment. It seems to be very, very effective. They do monitor me for drugs and alcohol. I have to take full screen urine tests once a week when I go in, just to monitor levels and make sure I'm on the right path and that I'm addressing all of the issues aside from just having a drinking problem. But I know it's going to be an ongoing maintenance thing. And again, I'm taking it very seriously. I haven't consumed alcohol. I just want to get back to my normal life and move forward.
Well, Ms. Boyd, I'm pleased to hear that you've taken the step of getting into treatment. That's the best thing that you can do for yourself and for everybody involved in this case. So I need to congratulate you on that and say thank you for doing that. I think hopefully this is you recognizing that what you've been doing, it's not a matter of just willpower. I think in the past you said, well, that, you know, my past criminal history was just, well, I'll just do better next time. This is the 6th criminal matter that's been brought before the court. Now, I'll admit that it's been over a long period of time. One of your cases was back in 2003, so 22 plus years old. But still, if you come before a judge 6 different times and you haven't figured out that you got an alcohol problem, that's on you. So I'm hoping that this is you saying, all right, I'm done fooling around with this. I'm going to get it taken care of. Unfortunately, alcoholism is a lifelong problem. So it's not just a one and done. I can do the treatment and then I don't have to worry about it for the rest of my life. This is you saying, I can't drink, period, for the rest of my life. What has your treatment told you about the potential use of marijuana while you're on their program?
She approved it because I have my medical card for it and just the whole plethora of things that it alleviates it's very beneficial.
When you went and got your card, had you told the doctor about your alcoholism and your other outpatient treatment, or how long ago did you get your card?
I got my card a long time ago and I renewed it the way that I am supposed to. When I got my medical card originally, it was for a shoulder injury. eating problems, sleeping problems, things of that nature. And I've maintained my card, but every time I've gotten it renewed, I haven't been in a place where I've been drinking. So because I went long strides with it, and again,
Yeah. So
know that
here's
I
what
have.
I want you to do. You have the right. You have the right to have a medical card and to use that for medical purposes. But I want you to go in and talk to your medical doctor about whether marijuana mixes well with whatever medication you're currently on, and whether it would be, I want you to talk to your therapist about whether marijuana would cause you some trouble if you're trying to wean yourself off of alcohol. In the past, I'm the sobriety court judge here, and so I've found that some people have difficulty becoming sober if they're still using what the federal government calls as an illegal substance. Obviously, Michigan doesn't. Michigan allows you to have a medical card, but if you're going to be clean and sober, I want you to have the best opportunity to do that. And if marijuana is going to interfere with that, then we need to talk about that. And I'm not the expert, so I'm gonna rely on the doctors to tell me that information. But the doctors need to have that information, so it's not you self-medicating with something else, and then you fall back into alcohol in the future. You understand what I'm saying?
Yes, part of my program is MAT, medical assisted treatment. So they are all very aware. The biggest bonus of the treatment program that I am doing now, because everything else I've tried clearly hasn't worked. I'm in IOP, medical assisted treatment, and my primary care physician. They're all in the same group. They all have access to everything. We're all working as a team. I've learned the very hard way, that I can't do it by myself, and I can't do it with just one friend or one family
Yep.
member, but between Bill and the whole team at Bear River, it's a group effort. Sort of takes a village
Good.
thing. As far as medical anything goes, they are fully aware of everything. And again, like I said, I have to take urine screens for them, and so we're working towards the plan just progresses, and we know that the ultimate goal is no alcohol at all, period, and to maintain a healthy lifestyle. But we alter the plan as we go, and if it does become a problem, they will definitely let me know.
Well, here's what I'm going to do here. I appreciate that information, and I'm glad that you're doing that. That is the best way to proceed. I am going to require that you have a medical review of the use of marijuana. And if the doctor says fine to use, then you get to use it. If the doctor says, nah, I don't think so, then you don't get to use it. Okay, so all I can say is I've had enough trouble with people in the past, and I don't want you to stumble this time, because if you stumble this time, the only alternative I have is to put you in jail. And I don't want to have to use that. But you've got to get this. This has got to be the priority in your life. This has got to be where you're going is sobriety. And if you're using something that's going to be, while it's legal, if it's going to be an impediment to that, then I want to remove that impediment. Okay. And I'd be telling you the same thing if this was Oxycontin or if it was some other drug. If it's going to be a problem for you, we're going to get it out of the way as much as we humanly possibly can. All right. All right. Is there anything else that you want me to be aware of before I impose sentence?
No, just that I'm looking forward to being back with my fiance. Like I said, aside from, I can't count on one hand how many times we've argued over the past 2.5 years. He's good for me. He keeps me in line. I think that as soon as he can be involved in my joint effort with the whole team at Bear River to continue ongoing care, I think things will get better, and I just want to move forward. Like I said, I can get my fines paid today.
Okay,
I
that sounds good.
It's the inconvenience in the court. I apologize to Bill. I apologize to the public for having to witness that.
All right, I appreciate all of those statements from you. Thank you. I'm going to put you on probation for 6 months to make sure that we can monitor how things are going, and so that you have a court presence watching over you, making sure that you're doing those things. It appears to me that you are self-driven at this point, and that's the best way to be. But I just want to make sure that you know that somebody's watching for that period of time, so that it becomes a habit, becomes ingrained, and then you can make those big changes in your life. There's a mandatory crime victim fee of $75, a justice assessment of $50. I'm going to lower the court costs to $100 and the fine to $50. There's a local fee of $15. That's a total of $290. You can pay that over probation or earlier if you wish. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation department. I'm going to require you to enroll in and successfully complete the treatment or educational program recommended by Bear River. Plus, I am going to require a medical review of the use of marijuana and follow doctor's orders. Excuse me.
Your Honor,
Yes.
I have a question about probation. As far as having to move because I can't afford my current home, one of the primary options at the moment, one of the only primary options is out of state. And that would be coming up very soon. The end of my lease is July. And is there any way I can do more community service or pay more fines and costs to not have to be on probation so that I can move, because it's kind of all up in the air. I have to definitely.
Yeah, as long as we know where you're going and have a way to contact you when you get there, I don't believe that moving out of state would be a problem. We can still monitor your progress. Most of the probation reporting is over the internet via Zoom, like we are today on the court. So as long as you're making the progress between now and then that you should be making, and you're doing the things that you need to do between now and then, I don't anticipate a problem with that. So I think you'll be fine. Okay. All right.
No contact getting good.
Let me get there. I'm still working my way through it. So let me tell you what I'm going to do, and then we'll answer your questions. All right. The Catholic Human Services Substance Abuse Assessment says that you may need an alternative 12-step program to AA, or you may need a more thorough substance abuse evaluation. I'm going to rely on the Bear River people to tell me what needs to be done for you. So you're going to do whatever Bear River recommends. If they tell you to go to AA 3 times a week, then you go to AA 3 times a week. If they tell you to go to an alternative program, or however they set it up, that's what you're going to be required to do. So I'm not going to put a definite limit on that or a mandate on that. That's up to the Bear River folks to tell me what you need. You may not go into a business where alcohol is served by the glass, that is no bars, even if they happen to serve food. You can go into a restaurant that happens to serve alcohol, but you can't go into the bar portion of the restaurant. And you obviously can't consume alcohol while you're on probation. You understand the difference there? All right. Alcohol and or drug testing at the discretion of the probation department. That is, that they can tell you when and how often you need to test. I am going to say no assaultive, abusive, intimidating, or threatening behavior. That should be a given. That's what we as adults are supposed to do. So I'm not going to say any particular person, but I am going to say no assaultive, abusive, intimidating, or threatening behavior. I'm not going to put you in jail while you're not employed. I am going to impose 3 days of work camp unless you have a medical excuse that says that you can't do the physical labor that they're saying that you would normally do. So it's typically raking and that sort of thing, physical work like that, but it's basically yard work kind of things. So I'm going to give you 3 days of work camp to think about what you did and to give back to the community for that. But I'm not going to put you in jail as a consequence of that. I'm not going to include a no contact provision with the victim in this case because he's asked that it not be put in place. And I do believe that you've showed me some good faith on your behalf. So the bond condition will be, which is what the order is right now. The bond condition of no contact will be lifted. So you will be able to have contact with that person. However, if there's a subsequent problem and you are charged with another crime, especially if it's a victim crime and he's the victim of it, that would likely result in your being incarcerated. Do you understand that? All right. Do you have any questions about the sentence that the court has imposed, ma'am? All right. Mr. Dick, any questions that you have?
No, Your Honor. Thank you very much.
Ms. Brucker, anything else that you want have me put in the course order?
No, Your Honor.
All right.
Did you add the probation fee?
I did not. Sorry. Thank you. My court staff has indicated to me that I forgot to add the probation fee, so that's another $180. So that would make the total $470 for fines, costs, and probation oversight fee. Can you pay that? You can pay all of that over the course of probation. If you want to pay it off early, you're able to do that as well. All right, that'll be the order of the court then. Thank you very much. Good luck to you, ma'am. I hope things go well for you.
Thank you.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.